All right, let's dive right into a truly mind-bending legal paradox from the Constitutional Court of South Africa. We're looking at a case that asks a pretty fundamental question about human error, the absolute limits of the law, and our pursuit of justice. Because, what exactly happens when a justice system does perfectly what it's designed to do, but ends up producing completely contradictory results? In this explainer, we're going to unpack a literal glitch in the legal matrix. It's a case that completely fractured the highest court in the land, and it forces us to really ask ourselves what fairness actually means when human beings are the ones in charge. Part 1, a glitch in the system. So back in August of 2001, this massive shockwave hit the South African legal system. Picture this. You have two legal cases that are materially identical. I mean, we're talking the exact same facts, the exact same points of law. They are both presented to the same Supreme Court of Appeal, yet they get decided on consecutive days with completely 180-degree opposite outcomes. On August 20th, Mr. Vanderwalt was denied his leave to appeal. Basically, he was denied permission to take his case to a higher court, so his legal journey just hits an absolute brick wall. But then, literally the very next day, Mr. Kitchley was granted his leave to appeal, meaning he gets to continue his fight. Which obviously brings us to our central mystery. How on earth could two identical cases, using the exact same set of facts, end up with completely different fates? And more importantly for you and me, what does it mean for the whole concept of the rule of law if your fate in court just comes down to which panel of judges happens to randomly read your file on a given Tuesday? Let's get some context in part 2, the franchise rebellion. Okay, to really understand this glitch, we have to look at the real-world stakes here, because real livelihoods were on the line. We're looking at a massive legal battle between a corporate giant and its franchisees. Metcash Trading Limited sued multiple franchisees all over the place for franchise fees and unpaid goods. These defendants included Mr. Kagatle over in Johannesburg and Mr. Vanderwalt down in Pretoria. Vanderwalt was acting as a surety, which just means he personally guaranteed the debts of his franchise. But the absolutely crucial thing to remember here is that Metcash's claims against all these different people were founded on the exact same standard form franchise agreement. So, because they were facing the exact same corporate lawsuit, the franchisees banded together. It was a full-on rebellion. They pooled their resources and agreed to use Mr. Cogley and Mr. Vanderwalt as mirrored test cases to fight Metcash. At first, both men actually managed to dodge a summary judgment, which is basically a fast-track win for the company suing you. But the courts ordered both of them to pay a hefty security deposit if they wanted to proceed. Well, they couldn't pay it, so judgments were entered against them anyway. That forced both men to petition the Supreme Court of Appeal to step in and save them. Which leads us to part 3, the Supreme Court paradox. Since they both lost at the high court level, their shared attorney petitioned the Chief Justice of the Supreme Court of Appeal. Now, because they shared the same lawyer and had totally identical cases, you'd logically assume their petitions would meet the exact same fate, right? Well, no. In this specific court, petitions are randomly assigned to a panel of 2 judges, and just 24 hours separated these rulings. One panel looked at Vandervalt's petition on August 20th and just flat out said no. Then a totally different panel of 2 judges looked at Kagetley's petition on August 21st and said yes. You can imagine the attorney panicking. He reaches out to the acting Chief Justice. Like, how is this even possible? And the response he got was just stunningly direct. The acting Chief Justice basically admitted, yeah, the system was designed to avoid this, but human systems aren't infallible. But the real kicker? Because of Section 21(3)(d) of the Supreme Court Act, both of those contradictory judgments were totally final, carved in stone. The Supreme Court of Appeal was legally powerless to go back and fix its own glitch. Now we hit part 4. The constitutional crisis. Vanderwalt has hit a total dead end at this point, right? So he takes the only path he has left. He escalates the whole thing straight to the Constitutional Court of South Africa. His argument was that this wasn't just a string of really bad luck. It was a severe constitutional crisis. He claimed these contradictory rulings violated the rule of law and his right to access the courts. But his biggest point was that this violated Section 9 of the South African Constitution, which is his fundamental right to equal protection and benefit of the law. And this sets up a massive philosophical dilemma. If a legal system applies the exact same rules and uses the exact same fair procedures, but gets entirely different results purely because of human discretion, is the system itself broken? Like, does equal protection under the law actually guarantee an equal outcome? Let's look at part 5. The majority and judicial discretion. So the Constitutional Court completely split on this question. Writing for the majority, Justice Goldstone ruled that, hey, both men actually did get equal access to the same procedures. The inequality only popped up in the final outcome. Goldstone emphasized that judges have to use their discretion to apply general rules to highly specific cases, so naturally reasonable minds are going to differ sometimes, and in perfectly good faith. To the majority, having different outcomes is just a natural feature of the system, not some unconstitutional discrimination. The Constitution protects the fairness of the procedure, not necessarily the correctness of the final decision. Actually, scratch that. They went even further. The majority pointed out that this whole glitch could have been totally avoided. They basically blamed the procedure. The attorney failed to lodge the petitions at the exact same time. On top of that, the petitions themselves didn't explicitly mention that they were part of this mirrored test case strategy, and no one ever alerted the Chief Justice to consolidate them into one case. So as far as the majority was concerned, the fault was squarely in how the attorney used the system, not a flaw in the system's architecture. But then we have Part 6, the dissent and equal protection. There was a super passionate minority of judges who completely disagreed with the majority. They demanded absolute equal protection, regardless of the procedural steps. Justice Sachs used this incredibly vivid metaphor. Imagine twin, parallel tracks of litigation, arriving at totally different destinations. For the dissent, this had absolutely nothing to do with whether the judges acted in good faith. It was just an objective failure of justice. If one citizen gets to go to trial and the other is forced to pay a massive judgment based on the exact same facts, the justice system has objectively failed to be fair and even-handed. Justice Ngobo really hit the nail on the head here, arguing that treating similarly situated litigants differently is just inherently arbitrary. He made the point that if your fate in court depends on which panel of judges you draw out of a hat or what day they happen to open your file, that is not the rule of law. That's literally the whim and caprice of an absolute monarch. The dissent strongly believed that equal protection demands that identical cases be consolidated and treated alike, specifically to avoid this exact kind of manifest injustice. So we're left looking at this epic clash of ideals at the absolute highest level of constitutional law. On the one hand, you've got this very pragmatic defense of judicial discretion. The reality is, human judges are going to disagree, and as long as the procedure is fair, the Constitution is satisfied. But on the other hand, you have this principled demand for absolute equal protection. The idea that a system simply must self-correct when it spits out arbitrary unequal results for identical citizens. But, in the Supreme Court, the majority rules. Ultimately, the Constitutional Court dismissed Mr. Vander Walt's application, and to make matters worse, he was even ordered to pay the legal costs for bringing the constitutional challenge in the first place. He literally reached the end of the road and faced financial ruin, all while his identical counterpart, Mr. Codtele, got to happily proceed forward to fight his appeal. Which leaves us with a pretty lingering, provocative thought to take away from this whole explainer. We try so hard to build our justice systems to be blind, impartial, and perfectly fair. But at the end of the day, they are operated by human beings interpreting really complex rules. So in any system run by human minds, is a perfectly equal outcome a reality we should actually demand? Or is human fallibility just an impossible glitch in the matrix, the inevitable price we have to pay for having human judges instead of algorithms?